Ready, start. On sale of any immovable property vested in him to any person and on receipt of the sale proceeds of such property, the custodian has to issue a certificate of sale in favor of the transferee, and even in the absence of handing over the original title deeds of the property, the sale in question shall be valid and conclusive proof of transfer of ownership of such property to such person, who has the certificate registered in his name, full stop. Such transfer is obviously from the owner of the enemy property, who is represented by the custodian, who only executes the sale and transfers the ownership of such property from the ownership of the enemy, enemy subject or enemy firm to the buyer of such property, full stop. The custodian does not sell the enemy property as the owner of such property, as no ownership rights are vested in him. Full stop. Section 15 of the Act states that the custodian may call from persons who, in his opinion, have any interest in, or control over, any enemy property vested in him under this Act, such returns as may be prescribed, full stop. In such an event, every person from whom a return is called for shall be bound to submit such return within the prescribed period, full stop. All such returns shall be recorded in such registers as may be prescribed, which shall be open to inspection subject to reasonable restrictions as may be imposed by the custodian, if in the opinion of the custodian, the person seeking inspection is interested in any particular enemy property as a creditor or otherwise, full stop. Such being the position of a custodian, who under the Act, acts as the trustee for the enemy property under the Act and not as the owner of the property, but as a protector of the property vested in him, the custodian can never be an owner or having any right, title or interest in the enemy property as owner, full stop. While Section 5-B states that any law related to succession or any custom or usage governing succession of property shall not apply in relation to enemy property under the Act, as no person, including a legal heir and successor of an enemy or enemy subject or enemy firm, shall be deemed to have any right, title or interest or any benefit arising out of such property in relation to enemy property, this provision does not at the same time confer any right, title or interest or any benefit arising out of enemy property in the custodian for enemy property, full stop. A custodian is thus only a trustee of the enemy property, full stop. In the absence of any transfer of ownership or any benefit arising from enemy property being conferred on the custodian, he acts merely as a trustee of the said property and not as the owner of enemy property, full stop. The explanation to section 5 within bracket 3 states that for the purpose of that subsection only, single inverted comma, enemy property vested in the custodian, single inverted comma clause, shall always be deemed to have included all rights, titles and interests in or any benefit arising out of such property vested in him under the Act, full stop. This is by a deeming provision and by a fiction only for the limited purpose of extinction of rights of succession on the death of the enemy, or extinction or winding up of the business of enemy property or change of nationality of the legal heir or successor, full stop. Thus, if no ownership rights are conferred on the custodian and he is appointed vis-a-vis any enemy property as a custodian, in law, he cannot be constituted to be the owner of such property. Full stop.